and then we have Mr. Number 51, number 51, 2024, arising from criminal sexual case 124, Katanga Moli applicant versus start with the background. Katanga Moli herein after referred to as section 188 and 189 of the Penal Code Act. The prosecution alleges that the applicant, Katanga Moli, on the second day of November 2023 at Ngoya 1, Ngoya Hill Village, Nakawa Division, Kampala District, with malice aforethought caused the death of her husband, Katanga. Legal basis, the applicant brought this application by notice of motion under Section 15 of the Trial on Indictments Act. Herein after referred to as the TIA and guidelines 2, 12, 13, and 14 of the Constitution, bail guidelines for courts of justice, guidelines for orders that the applicant be released on bail pending the hearing and disposal of criminal session case number 100 of 2024. The grounds of this application are stated in the application and further detailed in the affidavit in support. Deposed by the applicant briefly include that the applicant has the right to be presumed innocent until proven guilty by a court of competent jurisdiction, that she has a constitutional right to apply for bail, has sound and substantial sureties within the jurisdiction of this honorable court, capable of ensuring her attendance of court whenever required in the event that she is released on bail, has a fixed place of abode at Ngoya 1, Ngoya Hill Village, Nakawa Division, in Kampala District, within the jurisdiction of this court, that she is the sole breadwinner of her family since the demise of her late husband and has a child of 10 years, totally dependent on her, that she suffers from health complications requiring specialized medical care, which the prison's health facilities are not competent to provide, and that she will not abscond when released on bail and shall honor all the bail terms. Presentation at the hearing. The applicant appeared by Zoom link from Zero Units Prison. The applicant was represented by two firms, KAA Advocates, which was led by Mr. Peter Karatz, assisted by Mr. It was to prove exceptional circumstances and that they will not abscond from the trial once released on bail. Counsel cited the case of Attorney General versus Joseph Mishale, Constitutional Appeal number 3 of 2005, where it was held that it is no longer necessary for the applicant to prove exceptional circumstances before the court. Counsel further cited the case of Foundation for Human Rights Initiatives versus Attorney General, where courts observed that the provisions of Section 15 of the Trial Indictment Act, then it was Section 15 and Section 16. The provisions of Section 15 of the Trial Indictment Act were only regulatory and did not take away the discretion of the court to grant bail in deserving circumstances. Counsel asserted that nevertheless, the applicant possesses exceptional circumstances for grant of bail and pointed out that the applicant suffers from grave illness, a fact certified by the Uganda Prison Service and Ulago Hospital Specialists as defined in the affidavit in support of the application. Counsel cited the case of David Chandi Jamwa versus Uganda, Supreme Court Miscellaneous Application number 09 of 2018, where it was stated that the medical reports by the applicant medical reports provided by the applicant or evidence of reference. The applicant at the age of 56 is of advanced age coupled with deteriorating health, presents health care needs that cannot be adequately addressed by the Uganda Prison Service. Counsel for the applicant cited the cases of Akuta Oluko Justin versus Uganda, Court of Appeal Civil Application number 160 of 2013, and John Kaye versus Attorney General, Constitutional Application number 25 of 2012, where it was held that a person of 50 years and above is one of advanced age. Counsel advised that the applicant will not abscond once granted bail, and cited the case of Foundation for Human Rights Initiatives versus Attorney General, where the Honorable Justice Bart Katurebe held that the most important condition for grant of bail is that the accused will turn up for his trial and will not interfere in any way with the evidence. It was submitted for the applicant that Section 16.4 of the TIA provides that the other factor that the court might take into account in making the decision to grant bail is whether the applicant might abscond from a hearing. In support of the fact that the applicant will not abscond, counsel stated that the applicant has a fixed place of abode, poses no flight risk, has substantial sureties, and there are no other charges pending against her. The other factors the applicant relied on were that there was the possibility of substantial delay of the trial, and that under Section 15.1 of the TIA, the High Court can at any stage of proceedings grant bail. The gravity of the offence should not be used against the applicant to deny her bail, as the circumstances of the case were that there was a domestic brawl in which the applicant suffered grievous harm and continues to suffer the consequence of the same harm. The applicant has not and will not interfere with witnesses if released on bail. The applicant is a sole breadwinner to her family, including an 11-year-old child totally dependent on her. The applicant has never been charged with any crime before, and there are no other charges pending against her. In reply, counsel for the applicant, for the respondent, submitted as follows. Whereas counsel for the applicant submitted that the main purpose of bail is to offer protection against pretrial detention, and the applicant has been in custody for over a year. The applicant's trial from a long time ago and was only suspended when the trial judge at that time suffered guilty. Section 16 of the Trial Indictments Act provides circumstances under which court may deny bail, including if the applicant has not provided for the satisfaction of court that exceptional circumstances exist and that he or she will not abscond when bail. Exceptional circumstances are provided for in Section 16.3 of the Trial Indictments Act to mean grave illness certified by a medical officer of prison, a certificate of no objection signed by the DPP, and the infancy or advanced age of the applicant. Guideline 14.1 of the bail guidelines emphasizes the position in Section 16 of the TIA. The respondent contended that the applicant has not provided evidence in support of the exceptional circumstances. Regarding the grave illness of the applicant, counsel for the respondent submitted that no new evidence has been submitted to support that assertion. That the issue of grave illness was already considered at the applicant's previous bail applications. Considering the same now would tantamount to reviewing of the decisions of the unsuccessful applications. Counsel stated that subsequent bail applications to the same court should be entertained only on fresh grounds or new facts which did not exist at the time the application was made, or where there has been a material change in circumstances that led to the rejection of the first application. 2020. The respondent contended that the first and second sureties were not substantial, while the first surety at the age of 76 was of advanced age and should not be backed from the laborious duties of a surety, and therefore should not be considered substantial. The respondent submitted that the secretary has a case pending against him of obstructing justice and therefore cannot be expected to impose bail conditions. It was submitted for respondents that the secretary's history of interfering with police investigations makes him unsuitable as a surety. In rejoinder, it was submitted for the applicant that whereas the respondent contends that but for the indisposition of the trial judge, the trial would have been fast-tracked, and as such, the applicant's right to bail has not been prejudiced. The right to bail is not premised on the speed at which a trial is conducted, but in fundamental constitutional principle. The applicant remains in custody with no certainty as to when her trial will be soon. The right to bail exists precisely to guard against such indefinite detention. It was submitted for the applicant that the decision in the case of Simon Peter and another versus Uganda criminal misdemeanor application number 007/2023, where the Indian Supreme Court case of Kegan Chandra was cited, holding that subsequent application in the same court must be premised on new information or changed circumstances was made per incuriam. The overriding consideration in a bail application was set out in the Supreme Court case of Foundation for Human Rights Initiative versus Attorney General Criminal Appeal 3/2009. The right to make an application for bail must remain preserved, and that, criminal application number 3, not appeal. That right to make an application for bail must be preserved, and that the TIA does not take away the right to make this application as guaranteed under the Constitution. The decision in appeal seeks to limit that right by creating a host of new conditions. Counsel for the respondent asserted that the decision is per incuriam. Counsel cited Article 132, Clause 4 of the Constitution, which provides that the decision of the Supreme Court on a point of law is binding, and added that the Supreme Court preserved the unfettered discretion of court to grant bail. Therefore, the barriers sought to be introduced by the Simon Peter decision would not be used as an impediment to bail, as the decision in that case was made per incuriam. Counsel for the applicant further submitted that the respondent's submissions disregard the right to fair hearing, the presumption of innocence, and the right to liberty, which are constitutional guarantees. The continued detention of the applicant has resulted in the deterioration of her health, her family being left without its central pillar, the suffering of her dependents, her employees facing uncertainty, and her livelihood being jeopardized. Regarding the sureties, it was argued for the applicant that the first surety is an uncle of the applicant, and as such is in a position of authority over her sufficiently to ensure she abides by her bail conditions, his age notwithstanding. The second surety has never been convicted or even charged with any crime in respect of which a complaint was entered against him in the police reference book. There is therefore no basis for impeaching his suitability as a surety. Counsel for the applicant further submitted that having met all the conditions for grant of bail, the applicant's right to be presumed innocent needs to be upheld. The applicant has proved the existence of exceptional circumstances, and that her grave ill health demands immediate release. At the age of 56 years of advanced age, she is not a flight risk for long delay of the trial, which has been voted indefinitely since November due to the indisposition of the trial judge, is a violation of justice. The gravity of the charge is no part to bail, as bail has been granted for similar charges before, and the corresponding submission of witness interference by the applicant and unfound. Counsel for the applicant submitted that it was just unfair that the application for bail be granted. The parties' submissions have been relied upon by this court where necessary. cross-examination. First, the analysis of the law and the evidence. Article 2360 of the Constitution provides that where a person is arrested, the court may grant that person bail on such terms as the court considers reasonable. Although the Constitution guarantees an accused person the right to apply for bail, court at all times retains the discretion whether or not to grant an accused person bail. See the case of Foundation for Human Rights Initiatives versus Attorney General. The primary principle for which a court may release an accused person on bail pending trial is the presumption of innocence. This legal principle, which is enshrined in Article 28(3) of the Constitution, provides that every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Section 15(1) of the Trial Indictment Act, in addition to upholding the right of accused persons to apply for bail, clothes court with the discretion to release an accused person on bail at any stage of the proceedings. Guideline 5 of the bail guidelines provides the general principles which a court may take into account while considering a bail application. The principles include the presumption of innocence, the right to liberty, applicant's obligation to attend a trial, discretion of the court to grant bail on such terms as court considers reasonable, and the need to balance the rights of the applicants and the interests of justice. Having examined the law on bail, I will now turn to the merits of the application. Right to apply for bail and court's discretion to grant bail. This ground has already been addressed as above, and it's clear that the applicant has the right to apply to court to be released on bail, with the court having the discretion whether to grant bail provided for under Article 2360. Second one is the presumption of innocence. The presumption of innocence is a constitutional one, and as noted above, the bail guidelines require this court to consider the principle of presumption of innocence and personal liberty in determining bail applications. In relation to personal liberty, the active principle in granting bail is that of upholding the liberty of the individual while simultaneously protecting the administration of justice. See the case of Abindi and another versus Uganda, miscellaneous criminal application number 20 of 2016. The presumption of innocence means that an accused person should not be kept in custody and deprived of his freedom and amusement. Bail should not be refused merely as a punishment that is in conflict with the presumption of innocence. On fixed place of abode and substantiality of sureties, first I'll deal with fixed place of abode. A fixed place of abode for the applicant must be within the jurisdiction of this honorable court, as it guarantees to the court that the applicant can be found in the event of absconding bail. To underscore the importance of the provision of proof of a fixed place of abode, it can be a ground for refusal to grant bail. It is therefore imperative for the court to be persuaded that the accused has a fixed place of abode, because it is a pointer as to the fact as to whether the applicant is likely to abscond when granted bail. Section 1648 of the Trial Indictments Act is instructive in this respect, as it provides that in considering whether or not the accused person is likely to abscond, the court may also take into account the following factors: whether the accused person has a fixed place of abode within the jurisdiction of the court or is ordinarily resident outside the country. The point made in section 1648 of the TIA is amplified by guideline 13K of the bail guidelines. While the law does not define the phrase place of abode, what is important is that the fixed place of abode must be within the jurisdiction of the court, considering the bail application. Where the applicant fails to prove that he or she has a fixed place of abode, Section 16(1) of the Trial Indictment Act provides that court may deny him bail. In the case of Foundation for Human Rights Initiatives versus Attorney General, it was held that the nature of the offense, antecedents of the applicants, and whether the applicants have a fixed place of abode in the court's jurisdiction should be strongly considered by the court in an application for bail. In respect of this application, the applicant states in paragraph 2 that in paragraph 2 of the affidavit in support of her application that she has a fixed place of abode at Mbuya 1, Mbuya in Village, Nakawa Division, Kampala District within the jurisdiction of this court. The applicant submitted a copy of a national identity card, the original of which she submitted for court's inspection and the introduction letter endorsed by the LC1 chairman of Mbuya Village, indicating that she is a resident in this area of jurisdiction. Paragraph 12AB of the Bail Guidelines provides that an application for bail shall contain the particulars of the applicant, accompanied by a copy of a national identity card and an introduction letter from the LC1 chairman of the area where the applicant resides. The village, parish, and district, as stated in the introduction letter, are well known and are within the jurisdiction of this court. By furnishing court with a copy of the national identity card and an introduction letter from the LC1 chairman, the applicant has satisfied the owner's placed on her to prove that she has a permanent place. Sikayongo Bashir versus Uganda, criminal seniors application number 158 of 2019. The other point to consider is that of substantial sureties. The term surety is defined by guideline 4 of the Bail Guidelines to mean a person who undertakes to ensure that the applicant will appear in court and abide by the bail conditions and who furnishes security which may be forfeited to the state if the applicant fails to appear in court. Therein lies the main duty of a surety. What is pertinent about surety is that there must be an indication that they have been advised of their rights and sureties, they identified themselves properly and have shown and proved their authoritative relationships in respect to the applicant, showing that they are able to exercise their authority and command appearance of the applicant in court when needed. Section 16.4b of the TIA provides that in considering whether or not the accused person is likely to abscond, the court may take into account whether the accused person has substantial sureties within the jurisdiction of the court capable of ensuring the accused person's compliance with his bail. Guideline 15 of the Bail Guidelines sets out factors that court shall take into account in determining the suitability of a surety: age, work and residential address, character and antecedents, relationship to the accused person, and any other factors that court may deem fit. Documentation in respect of a surety that must accompany an application to bail includes a copy of the national ID, an introduction letter of the local council and chairman of the area where the surety is ordinarily resident. The applicant in paragraph 25 of the affidavit in support of our application avers that she has sound and substantial sureties who have fixed places of abode within the jurisdiction of this honorable court. She added that all the sureties are aware of their duties to this honorable court, and in the event that she is granted bail, they undertake to ensure her compliance with all the terms set by this honorable court in the event that she is granted bail. The sureties the applicant presented were three. One, there was Honorable John Patrick Cavallo, a resident of Chanamugera, LC1, Chanamugera Parish, Naltuntu Sub-County, Kasanda District. He is a farmer and businessman and an uncle to the applicant. A copy of his national identity card and a letter of introduction from the LC1 chairman is attached to the application. Originals of the same were presented for court's inspection. The second was Mr. Geoffrey Kamuntu, a resident of Kasari, Bali, Sanga, Okrait, Sel, Namlanda, Ford, Kajansi Town, Council, Wachiso District. He is a businessman by profession and a cousin of the accused person. A copy of his national identity card and a letter of introduction from the LC1 chairman were attached to the application. Originals of the same were presented for court's inspection. The third surety was Major General Emmanuel Burundi Nyamisa, a resident of Muyahi village, Nakawa Division, Kampala, a retired officer of the Uganda Coast Defense Forces, a diplomat and businessman. There is a cousin and next door neighbor of the applicant. A copy of his national identity card and a letter of introduction to the MC1 chairman was attached to the application. Originals of the same were presented for court's inspection. By providing copies of their national identity cards and letters of introduction from the LC1 chairman, where they ordinarily reside, the surety satisfied the conditions set out in Guideline 15 of the bail guidelines. I am not persuaded by the respondent's argument that the first surety at the age of 76 on account of advanced age is not able to execute the duties of sureties which the respondent referred to as laborious. First surety, by virtue of his relationship as an uncle of the applicant, wields authority over the applicant to ensure that she abides by the conditions of bail in the event that she is granted bail. After all, the duties of a surety do not require the surety to physically convey the applicant's report to satisfy her bail conditions. Had that been the case, the age of the first surety would then have been disqualified. Accordingly, the declared blood relationships between the sureties and the applicant remains their suitability as sureties. I therefore find that the applicant has satisfied the requirement to present substantial sureties. Now look at exceptional circumstances. The applicant sought to rely on section 16(1)(a) of the TIA, which provides that court may refuse to grant bail if the applicant does not satisfy court that exceptional circumstances exist for her release on bail. Section 16(3)(a) provides that exceptional circumstances means grave illness certified by a medical officer of the prison where the applicant is detained as being incapable of being managed while the accused person is in custody. It was argued for the applicant that as a result of the domestic brawl of 2nd November 2023, the day Mr. Katanga retired, she sustained injuries which have compromised her health, and that the Uganda Prison Service is illegal to manage her health needs. In addition, the applicant was found to have multiple masses in her breast. In a report dated 8 February 2024 by a team of medical personnel at Mulago National Referral Hospital, among other examinations, a mammogram was conducted, and the findings were VIRAD2, benign findings. The applicant was diagnosed with post-traumatic stress disorder, hypertension, for which she was found to be on treatment, vertigo, probably due to benign paroxysmal positional vertigo secondary to head injury, resolving soft tissue injury, breast fibrocystic disease. The recommended treatment plan was that the applicant receives trauma-focused cognitive behavioral therapy, continues with her antihypertensive treatment and blood pressure monitoring, follows up with the ENT surgeon for the paranasal sinusitis and vertigo, and monitors breast symptoms and repeats mammogram in 3 years. On 15 April 2024, Uganda Prison Service prepared a report stating that a follow-up examination of the applicant had been conducted on 12 April 2024 at Luzira Women's Prison. It was stated that the applicant did not receive trauma-focused cognitive behavioral therapy, neither was there any follow-up with an ENT surgeon to address the applicant's paranasal sinusitis and vertigo as recommended in the treatment plan from Mulago National Referral Hospital. It was stated that on examination, she was found to be in fair general condition, and a mammogram indicated that the applicant had multiple fibrotic masses in the right upper quadrant of the left breast. The report of 12 April concluded by stating that assessment and monitoring of the multiple breast masses is beyond the capacity of the Uganda Prisons Health Services. I note that the report from Lago National Referral Hospital, dated 8 February 2024, states that the masses are benign and recommend monitoring of the breast symptoms. It was recommended that the mammogram be repeated in 3 months. It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where no exceptional circumstances exist. In the case of Uganda versus Kano Dr. Chiza Besije, Constitutional Reference number 20 of 2005, where it was stated that proof of exceptional circumstances in an application for bail is not mandatory. However, when an applicant seeks to rely on exceptional circumstances, as in this case grave illness, the applicant is required to satisfy the court that the grave illness is such that it cannot be managed while the applicant is in custody. So in the case of Nyanzi Yusuf Sirat versus Uganda, criminal miscellaneous application number 134 of 2021. Section 16.3a of the Trial Indictment Act requires the medical officer of the prison where the applicant is detained to state that the health needs of the accused person are incapable of being addressed while the accused person is in custody. Section 74 of the Prisons Act, Cap 325, provides as follows: removal of sick prisoners to hospital. 74.1 says, in the case of illness of a prisoner confined in a prison where there is no suitable accommodation for that prisoner, the officer in charge, on the advice of the medical officer, may make an order for his or her removal to a hospital, and in cases of emergency, the removal may be ordered by the officer in charge without the advice of the medical officer. 74 goes on to say, a prisoner who has been removed to a hospital under this section shall be deemed to be under detention in a prison from which he or she was so removed. Where the medical officer in charge of a hospital considers that the health of a prisoner removed to hospital under this section no longer requires his or her detention there, he or she shall notify the officer in charge, who shall cause the prisoner to be brought to the prison if he or she is still liable to be confined in the prison. 4 says every reasonable precaution shall be taken by the medical officer in charge of a hospital and the other officers and employees of the hospital to prevent the escape of a prisoner who may at any time be under treatment in the hospital. The officers and employees of the hospital shall take such measures to prevent the escape of the prisoner as shall be necessary, but nothing shall be done under the authority of this section, which in the opinion of the medical officer in charge of the hospital is likely to be prejudicial to the health of the prisoner. Section 75 of the Prisons Act, Cap 325, goes on to provide for security measures for prisoners in hospital. Section 16.3a of the TIA, when read together with Section 74 and 75 of the Prisons Act, Cap 325, denotes that where the prison facilities are inadequate, but the accused person's health needs can be addressed by procuring his or her attendance at external superior medical facilities, while the accused person is still in custody, by conveying the accused person to such superior facilities for medical attention as and when necessary, and returning her to the prison. Then the test of exceptional circumstances by reason of grave illness has not yet been met. And therefore, that the option to have the applicant access the medical attention that she requires outside the confines of the prison walls while in custody to ensure the implementation of the treatment plan recommended in the Lago National Referral Hospital report of 8 February 2024, pursuant to Section 74 of the Prison Act, up to 325, has not been explored. The breast masses having been found to be benign rather than malignant or cancerous, and the experts recommending that the masses be monitored and the mammogram be repeated every 3 years. Those masses do not qualify to be termed as grave illness, which cannot be managed while the applicant is in custody. In Sheikh Mohammed Yunus Kamo versus Uganda, Court of Appeal Criminal Application number 77 of 2017, Honorable Mr. Justice Christopher Madrama stated that Section 75 of the Prisons Act 2006, now Section 74 of the Prisons Act, Cap 325, allows prisons authorities to make a report that a prisoner is in need of outside medical treatment, inclusive of being admitted in hospital outside the prison. I accordingly find that the ground of existence of exceptional circumstances fails. I will now go to the decision. In this case, the applicant has, among other things, proved that she has a fixed place of accord, has substantial sureties, is of advanced age, is the sole breadwinner of her family, is a first-time offender, and that there are no other charges pending against her. However, the charges against the applicant are grave. In all cases where an applicant or accused person is charged with a capital offense, the court must always have in its mind the overarching consideration of the gravity of the accusation leveled against the applicant. As stated in the case of John Muhanguzi Kashaka versus Uganda, Supreme Court Miscellaneous Application number 18 of 2023, being of advanced age, first-time offender, and a sole breadwinner, all such factors which go to the applicant's credit recede to the background when weighed with the seriousness of the offense. In exercising its discretion on bail, court must consider all the circumstances of the case and consider whether it is in the interest of justice to grant the applicant bail. In the instant case, 10 prosecution witnesses have already testified. Disclosures have been made to the defense in respect of the other witnesses, and the hearing of the matter is set to resume on 10th March 2023 as a session with a view to expeditious conclusion of the case. In Young Z. Yun versus Uganda, Court of Appeal of Uganda, Miscellaneous Application 99 of 2013, it was stated that the granting of bail by court to one before court is essentially an act of the exercise by court of its discretionary powers. The court considers all that is before it regarding the application for bail and reaches a decision based on the rules of reason, justice, and law. In the premises, the application for bail is disallowed on the following grounds. The prosecution case is advanced with 10 witnesses having testified and all the evidence has been disclosed to the defense. The hearing of criminal case 0100 of 2024 is set to resume on 10 March 2025 and will be heard as a session to expedite its conclusion. Signed and sealed copies will be available.
Council, will they give us some interviews? Council. No, what is your next step? Tell me. Okay, good morning, members. Sorry for not putting the right case. Yes, today, what has happened in court, it was More Katanga's bail application. More Katanga is accused of murdering her husband, Henry Katanga. The incident which happened in 2023. So today, she had come to get the bail ruling from Judge Rosette. Unfortunately, according to the grounds they presented, court has declined to grant her bail on grounds that since she alleges that she has some health complications and sort of, there is no way they have shown the prison authority that they cannot do it. They cannot handle the illnesses. So, with that, court has declined to grant her bail, and the case is scheduled for more hearing on 10th March 2025. Other grounds where the reasons why they have declined to grant her bail, it's because that although she has some issues with her breasts, court has said that according to the report which was made by the prison authorities and from the experts, those issues, the issues with the issues concerning with the breast health can be handled, like they can be reviewed after like three years from now. So with that, court has declined to grant her bail over that issue. Among other grounds, you can go further and do what? You can go further and listen to the whole proceedings as they unveiled in court. So we are coming back on 10th March 2025 for further of the case. So far, prosecution has presented 10 witnesses in this case. Yes, there are 5 people who are accused for the murder case of Henry Katanga. That includes More Katanga, the wife, the 2 daughters, Martha Nkwanza, Patricia Kwanza, a medical practitioner, George Amanyire, and Otai Charis Shamba Boy. Thank you for watching. We are sorry for informing you late. I thank you. Have a good day. All right.